Welcome to Sidebar with Judge Dan Winslow. I am Judge Dan Winslow with the New England Legal Foundation, previously with the Massachusetts Trial Court. And Sidebar is a show about conversations about topics at the intersection of business and law. Today, we're really lucky to have with us a special guest, attorney Andrew Botti, who's an expert in the topic we're going to be talking about today, and that is non-compete agreements. Andrew, welcome to Sidebar.
Thanks, Judge. I really appreciate it.
Well, Andrew,
Glad to
before
be
we
here.
dive into the topic, I'd love to have the audience members hear a bit about you and where your practice and what kinds of things you're involved in on a day-to-day basis.
Sure. I'm a business litigator primarily, and I do things like enforcing non-competes. I probably had, dozens of cases over the years. I've been practicing for 33 years, and I do other kinds of commercial litigation. Usually it's companies fighting over something, and I do employment litigation, usually on the side of the employer. And I've handled a lot of non-compete cases, like I said, and you can go to my website. It's APB Law LLC to see some of the larger cases that I've dealt with during my career.
That's great. So it's apblawllc.com.
Correct. Yep.
Fantastic. Well, thanks for joining us today here at Sidebar. Let's just sort of set the scene a bit, just for basics. What is a non-compete agreement?
Okay, so a standard non-compete agreement basically is between an employer and an employee who tends to be in a position to learn about a lot of trade secrets and confidential information concerning the employer. So typically, what it'll say is that the employee is prohibited from working for a competing business for a certain amount of time, usually a year. I've seen a couple that were 2 years, but that's very unusual. It's typical that they are 1 year restrictions. And, it basically means that the employee can't go work for a similar company or the same type of company for that amount of time. The idea being that they will not transfer confidential and proprietary business information, even unwittingly, to the other company.
So an example of that might be people in sales. So they would know what the prospects are that are being chased by company A. If they go over to the competitor, company B, and at least in recent proximity to their exit from company A, they'd know where the
Right.
leads are. They'd know
Right,
the leads.
exactly. And also top executives that basically know everything about the business and about the company that they're working for. There's a substantial risk there. And I'll just say that these have been effective in Massachusetts since 1811. So they're nothing new. They've been around a long time. And I was involved in fighting against eliminating them, which happened about 10 years ago when I was the chairman of SBAIN. And I got
SBAN
into,
is a small business association.
yeah, of New England, right. Um, I got in to see Speaker DeLeo and shoot his ear off for about 45 minutes and told him why these were actually good for the economy. And nothing happened for about 8 or 9 years. But then eventually, the voices got to him, and he did sign or proposed a change in the law, which is quite different than what it used to be. And there were like 46 states that allow non-competes on an unconditional basis. So it's not like it's something new. And it's been around for years and years. And we'll get into this about how it affects the economy, et cetera, because this is one of the FTC bases for pushing what they've been pushing.
So the net of it, Andrew, is at least in Massachusetts, there's that you can have a non-compete agreement subject to certain guardrails.
That's right. That's
And
right.
and and four states don't. Do you happen to know the four states that do not allow non-competes?
California is the big one. I think I don't know this for sure, but I think it might be Oregon or Arizona or Arizona. I'm not 100% sure,
But
but
California is the big one of the four. And I'm just
Yeah.
curious, from a policy perspective, because you've been involved at the policy level in these discussions in your career, what are the pros and cons of having a non-compete, and what would the folks say who are opposed to non-competes say about that?
Okay. The pros are basically, like I stated already, about not having confidential business information being transferred to a direct competitor. And I'll also say that they're in the court system, because these are sort of common law agreements. They're not statutory in most instances. Um, the courts have a lot of leeway in terms of reforming the contract. So if the court thinks it's too long, or if it's too broad a geographical area, they can actually cut it down and make it what they think is fair or fairer. So they're not sort of set in stone. And the argument against them is a whole bunch of different things, like what the FTC came up with, harming the economy, um, harming people from getting new jobs, and those are the basic complaints against them. Okay, but again, like I said, in mass, we're talking about 1811. I think the mass economy's grown pretty well since 1811.
So basically, it's a balancing test. On the one hand, the courts will look at these non-compete agreements to say, hey, are the limitations for how long you can compete, or the geographic area that you can't compete, or the scope of the work within which you can't compete, and they balance that against the employees or the executive or salesperson's right to earn a living. They got to they apply their craft. They want to make sure that they're not, basically forced onto welfare, because they can at least earn money somehow in some way,
That's
even
right.
if it's not directly in competition.
That's correct. That is correct.
What were the changes that were done in Massachusetts, just at sort of at a high level? How
Um,
was the Massachusetts statute that was enacted differ from the prior practice under the common law?
um, the main difference was it requires payment of money to the person who sits out the non-compete period. Okay. So if someone's going to leave and they have a 1 year non-compete, they have to sit out. But if that happens, the company has to pay them for that sit out time.
Oh, is
And
that
it's
so?
not,
So even
yeah,
if like somebody's in a sales executive making 300 grand, they'd have to pay him 300 grand for the year.
no, it's not 300. It's a percentage of what they were making when they were with the company. But
I
it's
got it.
still, I mean, I was representing a company that used to do that voluntarily. Would pay for their sit out period of time. And like you said, it was a lot of salespeople, and they would get their basic, salary for that sit out period of time. So again, there's been a lot of liberality and adjustment that can be made to these agreements. They're not necessarily written in stone. And I think that's why they've survived for so long without many changes.
Tell me, have you in your practice, have you encountered any horror stories, sort of war stories about non-competes that you could share just to sort of illustrate the problem?
Yeah, I mean, I had a judge one time um, read the non-compete and think that it was too drastic for this one particular woman who was in sales, and it was a 1 year limitation, and the geographic area was New England. So what the judge did was she cut it down to 6 months, and she reduced the geographic area to only Massachusetts. So these things can definitely happen. There's no question about it. But I say for the most part, and I've had judges that have gotten off the bench, and I've discussed these with them, and they've told me that they don't like them because they don't like keeping people out of work. And I can see where they're coming from. But I'd say for the most part, there's flexibility, but I think most of the time they were enforced, as they were written.
there's some alternatives to non-competes. For example, an employee might sign an NDA or a non-disclosure agreement, or they might sign a
Right.
non-solicitation agreement. We're not allowed to contact existing clients or prospects, for example. And
Yeah.
and if an employee has signed those things, wouldn't the argument be, well, you don't have to have a non-compete. That's overkill.
Yeah. Those are very good post-employment agreements. Okay. And there's also something called an anti-piracy agreement that um, you swear that you're not going to try to take away employees from your ex-employer. Um, they are good. They definitely are good. But ultimately, they're not quite as good as the non-compete because they don't necessarily stop what could be inadvertent revelation of trade secrets, something that you don't even think about doing because you've been doing it in your old job for 10 years, and maybe a new company hasn't been doing it, and you just start doing it.
Yeah.
And that's kind of where the line is drawn.
So make the argument, because I heard you say earlier that part of the arguments against non-competes is that it's good for the economy if you get rid of them. Is there an argument to be made that non-competes are good for the economy?
Yeah, I mean, I think it's more that they're not harmful to it, if you want to put it that way, because like I said, we in Massachusetts, we've been dealing with them since 1811. Obviously, the economy's grown substantially since 1811. And I think it's really a matter of, like I said, since they were sort of based in common law, the judges had a lot of ability to modify them and make them quote unquote fairer if they thought that they were too harsh. But the argument that they hurt the economy is just not. It doesn't hold water in terms of what actually has happened over the decades.
So if a company hires an employee, let's say a salesperson who has a non-compete, and there's a violation of the non-compete, that is, that salesperson, or maybe not the salesperson directly, but that company then just coincidentally happens to be going after the same sales prospects that the salesperson was working at company A for company B. How are non-competes enforced?
Okay, so what you have to do, unlike a regular case where you file a complaint and then you wait 20 days for an answer, you have to go to court immediately with what we call injunctive relief request. So you can ask for a temporary restraining order, which could be granted the same day you walk into the courthouse. The other side doesn't have to be there. And then the court would set a hearing within a few days for injunctive relief after the other side's come in and made their case for why there shouldn't be injunctive relief. So these cases actually resolve themselves pretty quickly, one way or the other.
Basically, they take that first shot, and if the judge is with them, they're a winner, and if they're not with them, they're a loser, and then they negotiate an exit.
That's right. That's right.
Is the company B, the company that hires an employee subject to a non-compete, would that company itself have liability or
Yeah,
exposure, legal exposure?
yeah, they do actually. And typically what I do is I do name that company as a defendant in the case because 9 times out of 10, they know that the employee has a non-compete agreement and they're just ignoring it and hoping that nothing will happen.
So catch us up on what's this is an evolving area of the law right now, and there's been
Right.
some work afoot at the federal level. Could you just share with the audience, the viewers, what's been happening at the Federal Trade Commission on the topic of non-competes in the last several months?
Sure. So this idea of a ban of non-competes nationwide was first brought up by President Biden in 2021. And I think he asked the FTC to look into this possibility. Okay. And under the Federal Trade Commission Act, they do have the ability to stop unfair methods of competition. Okay. And that's under Section 5 of the Act. Under Section 6, it says they can make rules and regulations that go towards that end. That is, preventing methods of unfair competition. So what happened in this case was the FTC issued, a proposed rule. They have to put it in the Federal Register where it's publicly available. And in this case, it was about the rule was relatively short itself, but the publication in the Federal Register was like 150 pages long.
Hmm.
So I didn't read the whole thing. I'll say that. But when that was published, a lot of companies were outraged about it, frankly. And what happened was the the United States Chamber of Commerce, which is in Washington D.C., they filed a claim the same day that was put in the Federal Register. They filed a claim against the FTC for an injunction in the Northern District of Texas, which is a fairly conservative district. And they stated that this was not appropriate under the FTC manner of operation. And it did come out, which is very interesting, that the FTC had not tried to do something like this since 1978, I believe it was. So it's been a long time since the FTC has sort of been this bold and brash and said, oh, yeah, we do have the ability to, snuff out a national law. And the proposal went into effect in the Federal Register, I believe it was in April, and it was scheduled to take effect nationwide September 4. But as I said, the U.S. Chamber of Commerce, plus at least a dozen other business groups, jumped in on this, an injunction that they were seeking to prevent this non-compete violation thing from just disappearing totally. In other words, once it was effective on September 4, that would be it nationwide. You wouldn't have a chance to do anything. And all non-competes, the 30 million of them that they estimate are out there, would have been rendered nugatory. So the U.S. Chamber filed this injunction request, basically saying that the FTC was beyond its legal capacity to do what it was doing. And a bunch of other, business groups joined on that injunction. And the court did enjoin the enforcement of that regulation.
Yeah, I want to pause you. I want to pause you right there, Andrew.
Yeah.
So just to, sort of orient the audience a bit.
Yeah.
So, there's this legal concept called ultra vires, which basically means that an agency is allowed to regulate areas that are given to it by statute, by Congress. So Congress is accountable to the people. It's elected by the people. It can be replaced by the people. Agencies, not so much. They're the professional career employees. And so if an agency has statutory authority to, say, regulate ducks, let's say, for example, what the FTC has done here is they've said, we hereby define a cat as a duck. Therefore, it's within our power, right? They said we hereby declare that non-compete agreements are an unfair business practice. We have authority over unfair business practices, and therefore we hereby declare that those contracts are an unfair business practice and they're banned. That's basically it. That's in a nutshell, right? Yeah,
that's in a nutshell. That's what they were arguing. The interesting thing, though, is that the FTC Act is not really specific about what they can do to enforce their position. What typically happens, the FTC Act goes back to 1914. And what would typically happen in an FTC case is that they would get a letter, say, from a company president that said, look, something's going on here. Our competition is doing something that's not right. Can you look into this? And then the FTC would conduct an investigation, and then they would hold hearings, to find out what was going on and what in that specific instance. And then ultimately they would make a ruling, yay or nay, on what was happening in that specific instance. So that's a lot different than them sort of taking the hammer to nationwide contracts. There's no hearing or anything like that. I was interviewed on WBUR, and I was arguing with the professor from NYU about this. And she said that, well, the FTC got 25,000 letters saying that they agreed to do away with non-competes. And I'm thinking to myself, well, that's wonderful, except there's 320 million people in the United States, I mean, that's not really a large segment of the population. So, in essence, what they were arguing was that specifically that this would create 8,500 new startups, grow business by 2.7% annually, create higher earnings for workers, and tens of thousands of new patents. Okay. Now, I'm not sure how they arrived at these figures. Okay. But this is what they put in the Federal Register as justification for why they wanted the ban. There was a 3-2 ruling among the commissioners stating why they wanted the ban, but two of them dissented. And actually, the dissent from this Andrew Ferguson guy, I would like to read just a little bit of it
Sure,
into
yeah.
the record here. He said on April 23rd, 2024, the commission promulgated the non-compete clause rule. It bans all employee non-compete agreements in which an employee agrees not to work for his or her employer's competitor after his or her employment. It is by far the most extraordinary assertion of authority in the commission's history. Again, the last time something like this happened was almost 40 years ago. It invalidates 30 million existing contracts. It redistributes nearly $500 billion of wealth, and it preempts the law of 46 states. It does all this on the basis of a few words in the 110-year-old federal statute, which is the FTC Act. He says, whatever the final rule's wisdom as a matter of public policy, it's unlawful, and Congress has not authorized us to issue it. The Constitution forbids it, and it violates basic requirements of the Administrative Procedures Act. And so ultimately, the injunction that was requested was granted, okay, in July, I believe, by the U.S. District Court judge that had this in front of her. And she said at that time that what she was going to do was make a final ruling on the issue sometime in August. And so that's exactly what happened. Okay. The procedural mechanism in this part of Texas, apparently, you file an injunction for a request for a court order, and then you can turn that filing into a summary judgment motion. So, in other words, you don't really have to do two filings; you just do one, and then just change it to a summary judgment motion.
Right. So you basically go from the injunction to a judgment on the merits, so you can take an appeal from there.
Exactly.
Right.
And the FTC filed a 50-page opposition. They were quite adamant about getting this thing through. And I'll say that the injunction opinion found that the FTC lacked any substantive authority to do what it was doing. And ultimately, what happened was on August 20th of this year, okay, just a week or so ago, the court found that Congress had not affirmatively granted them, that is the FTC, the authority to make such a rule. And they found that the proposal exceeded the statutory authority of the FTC, and also that it was arbitrary and capricious in the sense that the agency did not act within its zone of, what it can do.
Yeah, they acted outside their statutory enabling clause, basically.
Exactly. And they also said this was unreasonably overbroad without any rationale for it being that way, which is all true. I mean, they came up with all these numbers, but no one really knows where they got them from. And as I said, I think the earliest reported non-compete case goes back to England, 1711. And obviously, just by looking around, we can see that, these agreements have not harmed the economy. Okay. the economy's grown despite the fact that these agreements are in existence. And the other interesting thing is, I'll say, the Silicon Valley in California has had a higher unemployment rate than Massachusetts for at least the last 10 years. Okay. And they don't allow non-competes in California. Okay. So this idea that you don't allow them means you're going to have more employment, it doesn't hold water. All right.
Yeah, it doesn't bear out with the facts. And it's also, in a prior life, I was a software executive in Silicon Valley, and I could see certainly in areas outside of California, you might be willing to pay an executive more if they're willing to sign on to a non-compete, because you could know that they weren't going to be running off with the company secrets.
Right. That's
Yeah.
correct.
Yeah, that's
That's
interesting.
yeah, and that's usually what is done. The courts examine the amount of what we call consideration, that is, in this case, money, that is given to hold the executive to a non-compete agreement. So that does make a big difference, actually. It really does.
So let's have a prediction then, Andrew. This is going, you think, to the U.S. Supreme Court ultimately?
Yeah, I think what's going to happen next wouldn't surprise me at all, is that this will be appealed to the Sixth Circuit, which again is a very conservative circuit in terms of federal judges. And I think the reasoning was so good in the summary judgment motion decision that I think the appeals court's probably going to follow it. And then because the FTC has started this battle and definitely doesn't want to see it end by their own means, is likely going to appeal that decision to the U.S. Supreme Court. And I wouldn't be surprised if they took that up, because the way the summary judgment worked, it applied to every non-compete in the nation. Okay. The injunction itself only applied to those parties that were plaintiffs in the case. Okay. So you have something here that needs to be decided on a national basis. And obviously the Supreme Court can do that. Okay.
Right.
And I think that's why it's ultimately going to wind up there.
What's your prediction? What do you think is going to happen with this proposed rule?
I don't think it's going to go anywhere.
Do you think it'll be overturned?
Yeah, I mean, because the FTC hasn't done this in decades, okay, it tells you a lot about what they themselves think they could or could not do, And had there been a line of cases like this coming up to this one, I'd be hard pressed to say what I think was going to happen. But since there aren't any, I think this is going to be left as a states' right situation, okay, which I think it should be.
So vary by state by state. Well, listen, Andrew, it's believe it or not, we're coming up to the end of 30 minutes together, and I want to thank you. But that's it for this week's Sidebar. I want to thank you very much for joining us today. Andrew Botti, apblaw.com. Thank you very much. Thank you all for joining us as well. This is Judge Dan Winslow, and make sure you do justice. Thanks all.